way, and there's.
As Mr. Shaughnessy called her, the plain dealer lady is now stuck in the back row. Oh, unfair. You sat through the whole thing. We are on the record in the state of Ohio versus Michael Brelo. All counsel and the defendant are present. In many American places, people are angry with, mistrusting, and fearful of the police. Citizens think the men and women sworn to protect and serve have violated that oath or never meant it in the first place. Some of these places are long familiar. New York City and Baltimore. Some were unfamiliar until incidents there laid bare the divide between the people and the police. Ferguson, Missouri. North Charleston, South Carolina. Probably not coincidentally, these places are mostly African American communities. Cleveland, too, is one such place, as the reaction and attention to this case and other recent events has shown. Every week, I pass a mound of stuffed animals left in memory of a 12-year-old that many people believe was murdered by the police. This animosity toward the police is fed not just by stories that TV watchers and internet clickers are attracted to, but by police officers' affronts, intended or not, to honest people treated as criminals, by unnecessarily brutal treatment of suspected arrestees, by daily slights and disrespect, real and imagined, and by the isolation of the police from the people they serve. These realities in some neighborhoods have nourished attitudes toward the police, ranging from wariness to outright hatred. And these feelings existed long before they gained prominence through the proliferation of smartphones, surveillance cameras, and other recording devices that let pictures and news of violent police-citizen encounters quickly saturate the internet. Some say the volatile relationship between police and the community is rooted in our great country's original sin. Whether it is or not, that sin won't be expiated, and the suspicion and hostility between the police and the people won't be extirpated by a verdict in a single criminal case. If defendant Michael Brelo is not guilty of the manslaughter of Timothy Russell and Malissa Williams, if the evidence did not show beyond a reasonable doubt that he knowingly caused their deaths in violation of the Constitution, then I will not sacrifice him to a public frustrated by historical mistreatment at the hands of other officers. At the same time, if the evidence did prove the charges beyond a reasonable doubt, then he will be found guilty and punished as any other criminal. His badge and gun offer no special protection here. He and I took similar oaths to support and uphold the Constitution. If the evidence shows that he violated his, he can be sure I will honor mine. But whatever the verdict, it is a conclusion about the evidence in this case only. If he is guilty, it doesn't mean the entire Cleveland Police Department is dysfunctional, incompetent, and uncaring. If he is not guilty, the verdict does not mean the department covered itself in glory on November 29th. And guilty or not guilty, the verdict should be no cause for a civilized society to celebrate or riot. Whatever the outcome, 2 people are still dead and the defendant's life is forever changed. I have Mr. McGinty and Mr. D'Angelo a 35-page verdict that I will spare you the reading of the entire thing. There are probably 10 pages or so that I do want to read on the record in open court. The rest, of course, you will have in moments. So, the state has to prove that the defendant shot these 2 people knowing that death would probably result. But the state also has to show that the conduct was the actual cause of the deaths of Russell and Williams. Timothy Russell had 23 gunshot wounds. The medical examiner who performed his autopsy, Dr. Williams, numbered the wounds sequentially in cephalocaudal head-to-toe order, not the order they were sustained, so that wound number 1 is at the top of Russell's head, wound number 2 lower on the head, and so on down to 15H. Of the 23, both wounds 1 and 2 to the head would be fatal, taken alone. The 9 wounds labeled as 15A through 15H together would be fatal, combined. These are wounds that were penetrating shots to the chest and abdomen, and for which Dr. Williams could not determine necessarily specific wound paths. But of these, 15B from a bullet that pierced the heart and lung, and 15C from a bullet that perforated the heart would each be fatal by itself. Wound 1 at the top of the head is from a bullet that entered there less than an inch left of the midline and lacerated, among other structures, the left basal ganglia, which controls movement. Williams testified that the trajectory of that wound was down from the top to the left of the decedent's body and from the back toward the front of Russell's body. Wound 1 was immediately incapacitating to Russell so that he could not move, and by itself would have killed him within minutes. Wound 2 is another penetrating wound to Russell's head on the side, entering 2 inches to the right of midline just above the right ear, and injuring the brain stem, which controls respiration and heart rate. Dr. Williams testified that this bullet caused a nearly immediate death. Like wound 1, the path of this bullet was down from Russell's right to his left in that basic direction, and from back to front. Russell incurred the head wounds, indeed all of his wounds, while sitting on the driver's side of the Malibu's front bench seat. Other than that, his movements are not known, and his exact position at the time he was shot in the head is not known. What is known is that after the shooting stopped, he was found sitting back in the car and slumped to his right, resting against and a little behind Williams' left shoulder. Because Russell's head wounds were incapacitating, that is to say, he wouldn't be moving after either of them, and because they were so close to each other with such similar trajectories, they either came from the same gun in rapid succession, or nearly simultaneously from two separate shooters positioned near each other, and that shooter or those shooters would have been to his right on the car's passenger side. There is no evidence that Brelo ever shot his gun toward the Malibu from its passenger side. Wound 15B is a penetrating wound to Russell's left upper chest. The bullet that caused this wound came in from Russell's left and went right front to back, where it entered the heart and would have killed Russell within anywhere from several seconds to a minute. Wound 15C is a penetrating wound to Russell's right upper chest, about 3 inches from 15B, but on the other side of midline. Like 15B, the bullet that caused 15C hit Russell's heart, and taken alone would be fatal. Also like 15B, after sustaining this injury, Russell could have remained alive for a couple minutes, maybe, according to the testimony, and could have still operated a car. But unlike 15B, which came from the left, 15C came from the right and went left. In other words, the opposite direction of 15B. Brelo stands accused of illegally using deadly force against Russell and Williams from the trunk of Zone Car 238 and the hood of the Malibu. His final 15 cartridges were spent while on the Malibu's hood. It took 7.392 seconds to fire all of those shots. And they all came from the same place. Although Russell could have been positioned relative to Brelo's gun barrel in a way that would have exposed either the top of his head or the right side of his chest or the left side of his chest to a bullet with the trajectory of wound 1 or 2 for the head, 15B or 15C for the chest, it is highly unlikely, if not impossible, that during less than 8 seconds, Russell was positioned, then repositioned again so that all 4 wounds came from the same gun in the same place. I therefore cannot find beyond a reasonable doubt that Brelo took the 4 gunshots causing the 4 fatal wounds, any one of which by itself would have caused Russell's death. Dr. Philo did the autopsy of Malissa Williams. He identified 24 gunshot wounds, 6 of which, taken in isolation, were fatal. Wound 8 was caused by a bullet that entered just under the collarbone, about 2 inches to the right of midline and into the lung. That wound has a trajectory straight in, and from her left to right. The projectile that made wound 9 entered Williams' chest on a downward trajectory, went left to right, slashed the lung and pierced the ascending aorta. Gunshot wound 10 was on the right side of Williams' chest, less than an inch from the midline. The bullet that caused it had a downward trajectory, came from left to the right, and went through the sac around the heart and ripped the superior vena cava, the major vein that drains blood from the heart. Wound 11 is lower on Williams' chest and on the left side, about 2 inches from the center of her body, and was caused by a bullet coming down and also from left to right. This bullet went through the heart's right ventricle and lacerated Williams' right diaphragm and kidney. About 2 inches below wound 11 is wound 12. The bullet that came in here scuffed the heart and went through the left lobe of the liver and the stomach. Wound 12 has the same basic path as wound number 11, downward into the chest and from left to right. The last of Williams' unequivocally fatal wounds, number 13, is in her right abdomen, 1/2 inch from midline. The path of the projectile that came in here was upward and from left to right. And it hit the intestines, pancreas, inferior vena cava, and right renal artery. Wound 13 is the only fatal wound with an upward trajectory, and it is apart from the others. All 5 of wounds 8 through 12 are clustered within a distance from her head to her toes of 8 inches, and wound 13 is another 5 inches itself below wound 12. Dr. Fila describes all of wounds 8 through 11 and 13 as pre-mortem, which is to say before death. He testified that wound 12 is most likely pre-mortem. Williams also had one head wound that can be said in isolation to be fatal. Wound 1, not depicted on the mannequin, is just above her left ear. The bullet came straight in and penetrated the brain's left temporal lobe. If this injury was incurred alone, it would have caused instant unconsciousness, and Williams' heart would have stopped beating within minutes. Yet the party's experts differ on whether the lethal shot to the head came after Williams was already dead. Dr. Filo classified it as post-mortem because it is non-hemorrhagic, not bleeding. Dr. Rowe, the expert for the defense, characterizes it as perimortem, meaning the injury happened around the time of death, but whether it came before or after the cessation of life, the legal definition of death, can't be determined. Dr. Fila did agree that the term perimortem is an accepted term of art in pathology, and it is not just a hedge for a doctor unwilling to opine whether an injury is pre or post-mortem. Dr. Fila's testimony that wound 1 to her head was sustained after death, after the cessation of respiration, pulsation, and all of her other vital functions, combined first with his testimony that after the other fatal wounds to the chest, Williams would have lived for 12 to 20 seconds. And second, with the fact that the time from the first shot to the last was about 20 seconds, essentially absolves Brelo of causing her death if believed. The very latest Williams could have sustained wound 1 to the head was during the 20th second of shooting, which is to say the last shot. Subtracting from that the 12 seconds at a minimum it took for her to die from the fatal chest wound or wounds, she would have been hit by those bullets to the chest no later than 8 seconds into all of the shooting. And all of the shots taken by all 13 officers, including Brelo, during those first 8 seconds have been deemed by the state as legally justifiable. Even if one arbitrarily cuts off half the minimum time Williams would have lived after the chest wounds from 12 seconds to 8 seconds, and still assuming wound 1 was made by the very last bullet fired during the 20 seconds of firing, that excludes all of Brelo's shots during the last 7.392 seconds when he did the shooting that the state's expert considers not justified as causes of wounds 8 through 13. I detail this timeline to illustrate the imprecision inherent in a medical examiner's opinions. I am not critical of Dr. Filo's qualifications and abilities. I believe no pathologist could say exactly when Williams's heart beat and breathing ceased. But opinions are just that. One person's conclusions about an unknown fact based upon known facts combined with the expert's knowledge gained from education, training, and experience. An expert's opinions can be the difference between finding something beyond a reasonable doubt and not. They should be examined carefully. Having considered Dr. Filo's opinion, I believe he's either wrong about the time from the chest injuries until death, or he's wrong that wound 1 to the head was post-mortem. On the one hand, his estimate of the time from the chest injuries to death is based on years of experience and a rough mathematical calculation about the amount of blood pumped per beat of Williams's heart. On the other hand, his opinion that the head wound was non-hemorrhagic and thus must have occurred after Williams lost pulsation is based on his own examination of the injured area of the head and brain. Yet, given the extremely compressed time frame, I find that the fatal injury to Williams's head came before her heart stopped pumping and before her life had ceased. That leaves Williams with 7 separate fatal wounds. 5 of them, 8 through 12, could have been inflicted by one shooter in one position. But if they were, the high improbability that Williams' body was contorted in such a way that she was exposed to those 5 downward shots and an upward shot to her lower abdomen and a straight-in shot to the left side of her head leads me to conclude beyond a reasonable doubt that Brelo caused at least one fatal wound to Williams's chest, probably wound 10, and maybe all 5, but that 1 or 2 other officers inflicted 2 other fatal wounds, namely 13 to the abdomen and 1 to the head. Given these facts about the wounds to Timothy Russell and Malissa Williams, I cannot find beyond a reasonable doubt that Brelo took the 4 gunshots causing Russell's 4 fatal wounds, any one of which would have caused Russell's death. I do find beyond a reasonable doubt, as with Williams, that he caused at least one of them. I find it possible, but not beyond a reasonable doubt, that he caused 2 of them. I cannot, however, as mentioned, find beyond a reasonable doubt which of the 4 fatal wounds he caused. In Russell's case, it is likely that he is responsible for 15C, given that shot's downward and right to left trajectory, and Brelo's likely spot on the hood, more or less between Williams and Russell, which put Brelo slightly to Russell's right. So, for both Timothy Russell and Malissa Williams, I have found beyond a reasonable doubt that Brelo fired at least one shot which by itself would have caused Russell's death. But proof of voluntary manslaughter requires a finding beyond a reasonable doubt, either that his shot alone actually caused the death, or that it was, to use the words of Justice Scalia from Barrage versus the United States, the straw that broke the camel's back. Dr. Wiens opined that each of the 4 wounds was fatal if suffered alone, and she described all of them, these are the ones to Russell, as ante-mortem, which is to say before death. Her definition of death does comport with the legal definition, which, as I mentioned, is cessation of life, the ceasing to exist, defined by physicians as a total stoppage of the circulation of the blood, and a cessation of the animal and vital functions consequent thereon, such as respiration, pulsation, etc. In other words, since they were pre-mortem, any of these 4 wounds caused the death, and not necessarily the first to hit Russell, since the time from injury to cessation of life varied depending on the wound. In the end, as to Timothy Russell, Dr. Wiens could not offer an opinion on which ante-mortem wound caused death first, leaving me as the finder of fact to guess at which of the 4 undoubtedly deadly bullets caused the cessation of life. Guessing and being convinced beyond a reasonable doubt are not compatible. Brelo's deadly shot would have caused the cessation of life if none of the other 3 were fired on Timothy Russell, but they were. And that fact precludes finding beyond a reasonable doubt that Russell would have lived but for Brelo's single lethal shot. Similarly, with Malissa Williams, I find that 1 or 2 other officers inflicted 2 other fatal wounds, as I mentioned, 13 to the abdomen, 1 to the head. So with these killing wounds from 1 or 2 people other than the defendant, I cannot find beyond a reasonable doubt that but for Brelo's fatal shot or shots to Williams' chest, she would have lived. As with count 1, I therefore find on count 2 that the voluntary manslaughter of Malissa Williams that the element of causation has not been proved beyond a reasonable doubt. Having said that, the question of whether Brelo's affirmative defense has been proved by a preponderance of the evidence is not moot. Having found beyond a reasonable doubt that Brelo did cause a wound that would have killed both of these people, and having concluded that both of them lived for some moments, however brief, after those killing shots, he may still be found guilty of the lesser included offense of felonious assault, defined as knowingly causing serious physical harm. It is therefore necessary to address his claim of legal justification. First, I find, if not strictly as a matter of law, that as a matter of practicality, his claim of legal justification is an affirmative defense that he is required to prove by a preponderance of the evidence. But a preponderance of the evidence is a lesser burden than proof beyond a reasonable doubt. A preponderance is the greater weight of the evidence and only requires a belief that something is more likely than not. Pardon me. The Fourth Amendment to the United States Constitution provides that the right of the people to be secure in their persons against unreasonable searches and seizures shall not be violated. Whenever an officer restrains the freedom of a person to walk away, he has seized that person. There can be no question that apprehension by the use of deadly force is a seizure subject to the reasonableness requirement of the Fourth Amendment. A determination of the reasonableness of a seizure requires analyzing the totality of the circumstances. The question is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them. Where an officer has probable cause to believe that a suspect poses a threat of serious physical harm, either to the officer or to others, it is not constitutionally unreasonable to effect a seizure by using deadly force. A reasonable perception of threat is the minimum requirement before deadly force may be used. The reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. The calculus of reasonableness must embody allowance for the fact that police officers are forced often to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. Earlier in the opinion, I already listed some of the police officers' observations during the chase that Brelo heard and which bear upon the question of whether Brelo had an objectively reasonable perception that the Chevrolet Malibu and its occupants presented an imminent danger of serious bodily harm to him or to the other officers. The initial report from Officer Van that someone in the Malibu popped off a round. Officer Seifers called that the passenger looked angry and was pointing a gun out the back window. Nans warning that the passenger had a gun. Seifers saying that the passenger is turning back around again, pointing a firearm. And another officer's call that Williams was possibly loading a weapon. Brelo was also aware of the length in both distance and time of the chase. Although he was driving one of the cars nearest to the Malibu, he likely knew that many other cars were in pursuit, yet Russell still would not stop. He knew Russell had gone over 100 miles an hour and ignored dozens of traffic controls. All of this would make him wonder why the people in the car were so desperate to escape. By the time the chase was near its end, Brelo had been led through parts of Cleveland unfamiliar to him, and at the school was in East Cleveland, a different city altogether. The entrance drive from Wymore to the parking lot was a dusty, dirty area where a driver could only see the car in front of him. As he was on that entrance, he heard a radio call of shots fired and another radio call that there was no way out of the parking lot. When he pulled to a stop, Russell was unexpectedly barreling down the driveway toward him and then slammed into car 238 to Brelo's left. He thought he saw both people in the Malibu with something black in their hands. Gunfire was erupting in front of him, apparently coming from the suspects, and the car was still running. Under the totality of these circumstances, he perceived an imminent threat of death or great bodily harm to himself and other officers, and he decided to use deadly force to seize the Malibu's occupants. The same decision was made by 12 of his fellow police officers, all of whom surely made many of the same observations as Brelo. I find by a preponderance of the evidence that Brelo's decision to use deadly force against Russell and Williams was based on probable cause to believe that they threatened imminent serious bodily harm to him and the other officers, not to mention the public. I therefore find that his initial decision to use force was constitutionally reasonable. It was reasonable despite knowing now that there was no gun in the car and he was mistaken about the origin of the gunshots. It is Brelo's perception of a threat that matters. Excessive force claims, like most other Fourth Amendment issues, are evaluated for objective reasonableness based upon the information an officer had when the conduct occurred. If a police officer's perceptions were objectively reasonable, his use of force is not unconstitutional, even if no weapon was seen, or the suspect was later found to be unarmed, or if what the officer mistook for a weapon was something innocuous. But my conclusion that Brelo was justified in his initial decision to use deadly force should come as no surprise to the parties, since the same opinion was testified to by the plaintiff's use of force expert, W. Ken Katsaris. The real dispute between the defense and the prosecution is whether Brelo's probable cause to use deadly force continued through to the conclusion of the shooting or disappeared about 8 seconds before he stopped shooting when he took an elevated position on the zone car and then the Malibu. Our review of Katsaris' testimony is valuable for perspective on this ultimate issue. In Katsaris' opinion, William Salupo reasonably perceived a threat justifying at least a shot at the Malibu and both of its occupants. In his opinion, Paul Box reasonably perceived a threat justifying a shotgun blast at Russell and Williams. In his opinion, Christopher Ehrig reasonably perceived a threat justifying at least 2 shots at Russell and Williams. In his opinion, Wilfredo Diaz reasonably perceived a threat justifying at least 3 shots at Russell and Williams. In his opinion, Brian Sabolik reasonably perceived a threat justifying at least 4 shots at Russell and Williams. In his opinion, Michael Farley reasonably perceived a threat justifying at least 4 shots at Russell and Williams. In Katsaris' opinion, William Demchak reasonably perceived a threat justifying at least 4 shots at Russell and Williams. In his opinion, Randy Patrick reasonably perceived a threat justifying at least 9 shots at Russell and Williams. In his opinion, Michael Rinkus reasonably perceived a threat justifying at least 9 shots at Russell and Williams. In his opinion, Aaron O'Donnell reasonably perceived a threat justifying at least 11 shots at Russell and Williams. Scott Sistek, according to Katsaris, reasonably perceived a threat justifying at least 12 shots at Russell and Williams, and Cynthia Moore, Brelo's partner, reasonably perceived a threat justifying at least 14 shots at Russell and Williams. And Katsaris holds these opinions about the other officers regardless of their tactical mistakes. Box was out from cover near the Malibu's driver's side. Ehrig, O'Donnell, and Rinkus were exposed on the passenger side. Or the safety of the positions these other officers took. Even officers who were behind cover and thus mostly protected from any shots coming out of the suspect's car were justified, according to Katsaris, in firing as many shots as they did. Moreover, in Katsaris' opinion, Brelo reasonably perceived a threat justifying about 34 shot at the suspects. So where did Brelo run afoul of the Constitution? As Katsaris put it, because at the point of going on the trunk of Zone Car 238 and then on the Malibu's hood, he is taking action that is not trained, not recognized, not safe, and put all the other officers in the vicinity at risk of his becoming a victim and their having to attempt to now engage to save his life. In other words, because Brelo put his own life in danger. Katsaris later buttressed that his criticism of Brelo stems from actions he took that were contrary to his training and not from the harm that could befall Russell and Williams from those actions, by testifying as follows. Question: but then why would it be unreasonable for him to get up and eliminate this threat? Answer: for the exact reasons he gave for why he did what he did, which were, in my opinion, not objectively reasonable decisions. Question: what do you mean? Explain that. Answer: because if you are in fear of your life and you're behind cover, I can't imagine the fear that you're going to have when you put yourself standing on top of a car in the middle of, as he called it, a firefight. That is not trained. It's not appropriate. It's not objective. And whatever subjective belief, this is Katsaris still, he had about his fear at that moment, was not objectively reasonable to put himself up in the middle of both crossfire and the potential of being shot either by officers or the suspects, which would then jeopardize the other officers who would have to go into a mode of saving the officer that's now down. You don't put yourself in a position of officer down in the middle of the situation that he was involved in. That's why it's objectively unreasonable. It's not trained, it's not appropriate. It's taking yourself out from behind cover. And you're putting yourself in crossfire. And you are putting the other officers in jeopardy of having to now, if you get shot, save your life, which risks their lives. Finally, when asked if Brelo would have acted reasonably had he continued for the last 8 seconds to fire from behind car 238 instead of the hood of the Malibu, he said, I would probably say so. To me, all of this demonstrates that Katsaris' point is not that Brelo's perception that the people in the car posed a threat of imminent serious bodily harm, which he needed to stop, was unreasonable, but only that his actions taken to get into a position to stop the threat were unreasonable. Katsaris seems more focused on the location of the shooting than the fact of the shooting. In any event, I am not bound by Katsaris' opinion that Brelo acted unreasonably. And if I reject his opinion, I can do so without necessarily relying on the opinion of Ron Martinelli, the defendant's use of force expert. Expert opinions are simply offered to help the finder of fact make informed conclusions about the implications and significance of the known facts. And those known facts are, first, the car was still running, and to Brelo's observation, the occupants were still moving. Until then, over 22 miles of driveways, sidewalks, parking lots, streets, roads, and highways, Russell had shown no intention of giving up. He had just rammed car 238, but his car was not so tightly wedged against 238 or blocked by 217, Brelo's car, to keep him from continuing to use the car as a deadly weapon. The possibility that car 238 could have been pushed by the Malibu to pin Brelo to the ground was not imaginary. Second, up to 3 other officers were not convinced by then that the threat was over, because 3 other shots were fired during Brelo's final volley of 15 during the last 7.392 seconds. Third, Sobolik, a reasonable police officer praised by the prosecution as having moral strength and courage, expressed a belief at trial that the car's occupants still posed a threat during the last 8 seconds. Additionally, Brelo was acting in conditions difficult for even experienced police officers to imagine. He was in a strange place at night surrounded by gunfire, sirens, and flashing lights. He and Moore had fired straight through their own windshield, thinking they were about to be shot and killed. He described it as worse than being under attack from rockets and mortars while serving as a Marine in Iraq. These and more are the totality of the circumstances happening when he decided to use deadly force. Brelo did not fire too quickly or at a person who was clearly unarmed or clearly unable to run him over. He did not fire at somebody walking or running away. Finally, Brelo acted in slightly more than the time it takes for a pro golfer's tee shot to fall, and less time than it takes to read this sentence. 4 weeks was spent in trial examining those 7.392 seconds in every detail. An adversarial trial has proved over the centuries to be an effective way to find the truth. But if there is an ideal place to step into Brelo's shoes and view those less than 8 seconds and the 12 that came before them, the way he did on the night of the shooting, it is not the artificial environment of a courtroom. Still, that is what the law requires. So I reject the claim that 12 seconds after the shooting began, it was patently clear from the perspective of a reasonable police officer in Brelo's position that the threat had been stopped, and therefore find that Brelo's entire use of deadly force was a constitutionally reasonable response to an objectively reasonably perceived threat of great bodily harm from the occupants of the Malibu, Russell, and Williams. Having so found, in summary, I find that the state did not prove beyond a reasonable doubt that the defendant, Michael Brelo, knowingly caused the deaths of Timothy Russell and Malissa Williams, because the essential element of causation was not proved for both counts. I therefore find the defendant not guilty of counts 1 and 2 as indicted. The state did prove the lesser included offense of felonious assault on both counts by demonstrating beyond a reasonable doubt that the defendant knowingly caused serious physical harm to both victims. But the defendant proved by a preponderance of the evidence that he is legally excused from liability for those crimes because he caused the serious physical harm to the victims in a constitutionally reasonable effort to end an objectively reasonable perception that he and the others present were threatened by Russell and Williams with imminent serious bodily harm. I therefore also find the defendant not guilty of felonious assault, the lesser included offense on both indicted counts, and the defendant is discharged. Thank you. We're off the record.
All right.
And you were watching live team coverage here. Michael Brelo found not guilty in all counts here in the verdict just handed down in his trial by Judge John O'Donnell. You see Michael Brelo, the 31-year-old father of 2, breaking down in tears and swiftly leaving the courtroom surrounded by sheriff deputies there.
We are joined right now on the desk by Jonathan Whitmer-Rich. He's assistant professor of law at Cleveland Marshall